May I please?
Yes.
Lordship, before coming to the impugn order, Lordship, just a short brief is that, Lordship, the petitioner is a Lance Nayak, Lordship, as constable working in Lordship, APPBN, Lordship. And he is posted at Chimpu, that's a headquarter. And he encroached over the lane which is allotted to very Lordship, that battalion where he is serving, Lordship. Accordingly, departmental proceeding was drawn against him, Lordship. And then, Lordship, the order was passed, Lordship, deducting to increment with cumulative effect. Lordship. Then it gone to Lordship, appeal was rejected. Then it gone to the revision, Lordship. In revision, Lordship, two increment has been, Lordship, reduced to one increment, Lordship. And against that, Lordship, order was, the petitioner approached this Honorable Court, Lordship, where the present impugn order has been passed, Lordship. Lordship, if Lordship come to the impugn order, that is at page, Lordship, 13, 13, Lordship. Operating portion is at page 15, Lordship.
Paragraph number?
Paragraph 6, Lordship. I'll read from paragraph 6, Lordship. I have considered the submissions of both the learned counsels. A person cannot be held guilty of having committed an offense which does not exist. It is admitted fact that the section 6 rule 2 of CC's conduct rules does not exist. For that reason, the charge against the accused cannot stand. Since the charge has no basis, the punishment or sentence given against the petitioner also cannot stay because it would have no basis to stand. This is for the opposite reason. I find that the impugn order that is so and so passed by the commandant of first APPBN BHQ Chimpu Itanagar by the order so and so is illegal, and accordingly the same is posed and set aside, Lordship. The impugn order which has been set aside, Lordship, that is, Lordship, kindly come to page, Lordship, 31, 31, Lordship. This is in terms of the order passed by this Honorable Court, Lordship, in the past litigation, Lordship. In the past round of litigation, direction was there to take a press decision, Lordship. Page 31, annexure 8, and I'm taking, Lordship, to the page 32, the operating portion, Lordship. May I read, Lordship? The last, Lordship. Therefore, bottom, Lordship. Therefore, in compliance with the opposite court order, following order are passed. The act of unauthorizedly occupying a plot of government land by Lance Nayak Tai Tache of first APPBN, which is under positions of the commandant, first APPBN since 1989, as per the government allotment order number so and so, dated so and so, amounts to misconduct under section 6, rule 2 of CC's conduct rules, Lordship. This reference of the section, Lordship, section 2, this is, Lordship, as such is not exist in the Lordship rules, Lordship. But what happened in this case, Lordship, when this error occur in the order, Lordship, then this was challenged and we file our affidavit, Lordship. Kindly come to the affidavit filed by the state government. That is at page 136, Lordship. 136. It starts from 135, Lordship. I'm sorry, 135, Lordship. And I'm taking, Lordship, to the page 145.
Yes.
Page 145. It starts from 135, annexure 10, but relevant is at page 145 and para 22. Lordship. In para 22, we have explained how it had occurred, Lordship. That with regards to the statement made in para 15(1) of the writ petition, the answering respondent not admitted and denied. It is submitted that, in fact, the commandant, the first APPBN Chimpu, while passing orders so and so, relied on clause 2 conduct and omission, which amounts to misconduct of chapter 6 conduct rules of SOMI's handbook for central government staff. Mutu Somiso and so and so. So this Somis handbook lawship, this is before main lawship. This here lawship, this misconduct has been referred in section 6 lawship. So we have referred this. This is the part of this is compilations of our CCS rules itself lawship. So this very conduct, which is amount to lawship misconduct, that has been given in this Somis handbook lawship. But why I'm selling this very impugn order? Because this aspect, though it has been clarified and explained in the affidavit in opposition, that part has not been discussed by the learned single bench lawsuit. That's one of my lawsuit ground why I'm before this honorable court lawsuit. At least that should have been considered lawsuit. And whether the conduct of the petitioner lawsuit is misconduct or not lawsuit. Earlier round of litigation lawsuit, this honorable court itself has observed lawsuit. The conduct is definitely lawsuit, is not lawsuit.
It took for determination of point. Charge to us, page to charge memo, page 77.
Lordship, here it's not the case that lawsuit, the authority who passed the order has no power lawsuit. The power can be traced to the statute, that's the rules laws. If that rule power is traceable, then in the very rules lawsuit, then lawsuit, so on our Supreme Court judgment is here lawsuit. It says lawsuit, there's no lawsuit, wrong quoting of the section and all. It will be not better for the lawsuit to the order lawsuit.
Mr. Tapin,
No.
the conclusion reached by your inquiry officer or the discipline authority, which you have now referred to, page 31.
Clause.
30, that, if we can come to that again. So merely possessing a land cannot be a misconduct. There has to be something more because you are trying to bring in clause 11 of that Swami's handbook.
No.
That if you come to 152, you will find 152. Have you got 152?
Clause.
Clause 11.
Clause.
Let us hope that is a wrong quotation. We give you that. Willful insubordination or disobedience is what is the misconduct. Where is the allegation of or the charge of insubordination or misconduct?
Lawsuit. Here lawsuit.
Where no. In your charge, that
This
was
rule 11.
forget it. Forget rule 11. But where is that charge of insubordination or willful disobedience?
That is not here.
That-
Therefore, lawsuit, here lawsuit, if lawsuit comes to 152 lawsuit, the act, conduct and omission which amount to misconduct lawsuit.
That is general. So now if you come back to your charge memo,
Lawsuit.
page 78, you will find it.
Lawsuit.
Where is that allegation against the delinquent that in spite of directions being issued to move away, clear off, he has not done that? That would have been a misconduct. Mere sitting over a plot of land, it would be an eviction proceeding.
But he encroached over the lawsuit.
Evict him.
Lawsuit, here lawsuit, the lease has been given lawsuit. What act and commission is amount to misconduct?
Forget that. We are only on the charge that has been framed. This has not been dealt with.
The charge is lawsuit, he illegally lawsuit.
Law, got it. That would be show me that it is a misconduct. This court directed you to come to a conclusion that this is a misconduct.
Correct.
So your conclusion is only 133, 1 and 2. Show me, this
No,
has
yeah.
a nexus with the,
No, may I read, Lordship? I would like to read it. If the act or conduct is prejudicial or likely to be prejudicial to the interest of the master or to the reputation of the master, Lordship.
fine, but you must specify that in the charge. You can't have a vague charge and then come to a conclusion which is not even contemplated.
But Lordship, that act of Lordship encroachment.
Why is it not here that you have insubordination, you have willfully disobeyed, all those things should have come here. And you should satisfy us
But
that the
in
direction.
Article 1 Lordship, he has illegally encroached over
There
the
is only one
government
article.
land. That's the issue.
Fine,
Lordship.
government
Whether
land
that act is amount to Lordship
misconduct.
misconduct or
So
not.
your justification is page 133.
130.
That is 31 and 32. Okay, you can come to 133, that impugned order.
Lordship.
You can come to one. Let us say that your reference to the CCS conduct rules is perfect, correct. Right?
Lordship.
The unauthorized act of so and so amounts to misconduct under 6 rule 211 of CCS conduct rules.
Lordship.
Now, 211 says,
No, that's what Lordship, we are saying, Lordship. This quoting of this provision is not
let us
correct,
say,
Lordship.
no, then show me that holding, illegally occupying a land
Lordship.
is a misconduct in itself. You come to 2. You come to 2.
Therefore, this, sir.
Where is that material? Where is that allegation against you?
Lordship, this 2 part also is not there. Lordship.
Then the whole order will have to go. Rightly interfered,
But-
maybe for different reasons.
But one Lordship.
Nothing. It's just vague. The charge is vague. Your conclusion is more vague.
No. From Lordship facts, we can Lordship at least deduce Lordship the gist of allegation.
You
Lordship.
cannot deduce something which you have not alleged.
The
You are
allegation is
deducing
that
something which you
Lordship,
have not alleged.
he has encroached over the government land.
Evict him or show that you had given notices to him to evict. He has not done it.
That is insubordinate. That part is not there, Lordship.
That-
But encroachment, Lordship, one master's Lordship, the property you have encroached over. Eviction is another part.
Mr.
Lordship.
Tapin, you have a
Eviction-
power. You have a power of eviction.
Eviction is
Or-
completely different Lordship, aspect,
Or,
Lordship.
or you have a power that, see, you are encroaching upon my land, leave it. He has not left it. You can charge him for
That
insubordination.
part is there, Lordship.
That-
Lordship, so far eviction is concerned. Eviction is completely different concept, Lordship. One is evicted. It doesn't mean, Lordship, what he has committed is, Lordship, not misconduct, Lordship. What he has committed, still that can be misconduct, Lordship.
Show me. That is what we.
Therefore, Lordship, I'm just reading the one page 52 lists are given what conduct is, Lordship.
That is too vague.
Lordship, this encroachment over own master's Lordship property, whether this is misconduct or not, Lordship. At least from these facts, we can understand, Lordship, this is amount to misconduct, Lordship. And the list which is given in 152, Lordship.
Yeah, Mr. Tabin, is there any determination that the land belongs to the commandant of the battalion?
Lordship, that part, Lordship, is here, Lordship, in evidence also, Lordship. He has admitted, Lordship, he occupied this land, Lordship, in year 1994, Lordship. And on records, Lordship, in evidence, he said, Lordship, version is different. When this highway, Trans Highway was constructed, Lordship, it cut between the Lordship, the very lane allotted to the APPBN. Some portion gone to the other side of the road, which he had occupied, Lordship. That's admitted in the part, Lordship. Evidence, Lordship. On evidence, it's there, Lordship.
Evidence in departmental process,
Departmental proceedings.
he admitted.
Here, Lordship, just if I take Lordship to the evidence, Lordship, kindly take up, Lordship, the additional affidavit filed by me, Lordship.
Additional affidavit.
Additional affidavit. It was filed on, Lordship,
Where is the evidence?
22nd December 2023.
Evidence, material.
Page 12, Lordship. Kindly come to page 12, Lordship. Before coming to page 12, Lordship, I would like to take Lordship to page 9, Lordship, which is written statement filed in response to the Lordship,
So cause notice.
no, the memorandum of articles.
Yes.
Regarding articles also, I am not denying that the APPBN has not have a allotment, land allotment. But regarding the questions of selling of tree, I am fully denied that I am not sold any trees. Where here, Lordship, only this part, Lordship, he is not denying that the APPBN has not been allotted this land. One, Lordship, admitted, Lordship.
Sorry, to upper to the proceedings. This is the reply to the earlier.
Earlier, the same thing, Lordship.
Therein only cutting of trees was the allegation.
No. I'm coming because it has been used as a evidence in the second department proceeding. And kindly come to page 12, Lordship. This is a statement of the delinquent official also. On examination, he stated this. Since January 1994, I was using the land as a kitchen garden and I have planted bamboo. There were no quarters in the office colony. After cutting off NH 52, some portion is left on the other side. Now I'm claiming the other side and I am not claiming the land towards the officers colony side. If I do not claim it, public are claiming it. If I leave, that other person will claim it. If I leave, that other person will claim it. There was some cattle tree in the said land. I did not cut and sell it. People were telling that Portland hand rooted it out while cutting the road. Who had taken it? I don't know. Do you know the land is allotted to APBN Itanagar? Yes, I know the land is of APBN. So I do not occupy the land towards the IG residence.
Okay, he admitted.
Admitted. And this is the statement in earlier Lordship, departmental proceeding, Lordship. And it has been used as a document in the second departmental proceeding. If Lordship see the second departmental proceeding, kindly come to page 35, Lordship.
No, whether fresh memorandum of.
Yes. Everything was done, Lordship. Done, Lordship. Page 35, Lordship. And relevant is page 36, Lordship. Down below lordship, Article 3, that what documents have been, list of documents are given, which have been used, lordship, during the departmental proceeding. Page 36, lordship. Down below, in the second document, lordship will find a statement of the delinquent that is dated 14/10/2015, which just now I have read, lordship.
Was it produced in the inquiry?
Lordship,
You have that, how it was produced in the inquiry?
inquiry.
Second inquiry, how it was produced? Who produced it?
This one,
This
It-
document?
it was by the department authority only.
Who? Which witness produced this?
Okay, okay. Lordship, it part.
Record to. In the inquiry report, there is any reference to this?
Lordship,
Same criminal. Same. This was not considered. Page 80-81. 80-81. Inquiry to Sagor, inquiry to circulation. Yes, 81, page 81-3.
page
Tungon.
Lordship. Page 47 also is there, Lordship. The same thing is there.
Ah,
Page 47.
Page number?
Page 47, the additional affidavit which. And the officials who have conducted the earlier lordship, delinquent lordship,
there.
they were examined in the second proceeding lordship. And the delinquent lordship almost declined the lordship cross-examination.
Page 40.
Page lordship, from page 14 lordship. Sorry,
40.
no. This is,
47.
it starts from lordship, page 13. Sorry, page 13, yes, lordship.
13 of the appeal or the
My affidavit.
affidavit.
It's still affidavit. 13. 13 onwards lawsuit. 13 onwards, it starts from 13 and relevant is lawsuit 20. SITS Swargari. Page 20. SITS Swargari. There was no cross-examination and lawsuit will find Tai Tachi's signature is there also. He put his signature. And next is Loki Bra. He's also one of the official lawsuit. He also stated loss during verification. It has been found that he is encroached.
Yes, Mr. Parman. Well,
May I please judgment to judge?
Give the copies, paragraphs.
No, sir.
Now, before coming to my lord, this specific reply, my lord, I will beg to start with my lord, brief break of the case, my lord. Now,
Please.
brief break of the case, my lord. I will start with my lord.
Okay.
Now, what happened, my lord? My lord, yes, my lord has seen, my lord. With 17/8/2025, my lord, past DE was initiated against me, my lord, on the allegation that I am claiming and sold the standing tree, my lord, to highway, my lord. Now,
The first citation lawsuit, para 6 is about the misconduct lawsuit. And next to judgment is about the lawsuit source of power lawsuit. Wrong quoting of the provision is not federal lawsuit.
now on that,
You have marked the paragraph here.
Lawsuit,
You have marked the paragraph here.
lawsuit, may I, lawsuit, I'll mark then.
Yes, Parman.
now, my lord, in past D, my lord, with order 18/11/2016, my lord, I was exonerated, my lord, from the charge, my lord. On that order itself, again, I was new charge issued to me, my lord. 18/11/2010, my lord. Subsequently, 17/11/2016, my lord, I'm just, it is not necessary, but then I'm new member of charge was issued against me, 17/11/2016, my lord. Now, by on 27/6/2017, my lord, I was found guilty, my lord, according to incrimination withheld, my lord. I make an appeal, my lord, on 18/7/2017, my lord. Now, as they did not consider, my lord, I approached this honorable court, my lord, by WPC number 393/2018, my lord. According direction issued to consider my appeal, my lord. Accordingly, that was considered, my lord. Again, I prepare revision, my lord. That was not considered, my lord. Again, I filed, my lord, WPC number, my lord, 7/2019, my lord. Again, direction is to consider my revision, my lord. Thereafter, my revision was considered, my lord, on 14/2019, my lord. Now, 14/19, my lord. That will, my lord, that is that page number, my lord. But that is not that will be not necessary, my lord. Thereafter, my lord, revisional order was passed on 14/2019, my lord.
Mr. Pami, we got the background. We got the background. Now only satisfy us whether is there any civil proceeding pending with regard to the land you have occupied?
My lord, my lord.
Civil proceeding pending.
Pending.
When?
My lord,
Where? Pending where?
CB now Civil just senior division, my lord, dismissed my suit, my lord, on technical ground. Now that is being,
That, so that suit, original suit that you filed is
my
set
lord,
aside.
now that
You agreed that this land you are occupying was initially allotted to the
APB.
APPN?
no, my lord, that time I indicate that also, my lord, that are their contention, my lord. Now, subsequently, my lord, this department itself, my lord, apply allotment from the authority, my lord, for this land, my lord. If that was allotted to them, there could be
Show that.
that, my lord, that is part of this, my lord.
When did they allow, pray for allotment?
Allotment after initiation, this my portion, but that is it. My lord will kind of have one page 127, my lord.
127.
This is survey report, my lord, by the LM, my lord. Is directed by authority to verify the purpose area of Simpu in connection with the survey the area for new police station in Simpu. I have surveyed the purpose area and gathered the following pick which are as follow. The land not allotted to any private individual or not allotted to any department. Police department not occupy on and not construct any structure on said plot. The lane near NFA and distance keep from the road is 15 meters. The lane is feasible for allotment in favor of police settlement. This is in terms of their applied to allotment. This survey was done by the authority, my lord, the authority for the lane, my lord. Now that is, my lord, I consider disputed. They are the authority, my lord. They have power, my lord. They level so many allegations against me, my lord. That I consider, my lord. And in terms of that, yes, some the senior counsel rely some documents, my lord, who I consider. Ultimately, I am just a constable, my lord. Whatever authority do me to state, my lord, I need to, my lord, I did to record, my lord. Now, but then, my lord, the whole allegation is still, my lord. The allegation under which misconduct was instituted, my lord. It says so, my lord, that is not based on some solid foundation, my lord. Because, my lord, this not only this, my lord, earlier occasion, my lord, when the acquisition, my lord, of the for this highway was carried out, my lord, the compensation, my lord, was paid to me by the authority, my lord. That also is not disputed, my lord. So my humble at this stage, not ever title, my lord. At this stage, department inquiry, my lord. It is prima facie case, my lord, is my favor, my lord, in terms of title of the land, my lord. Because, my lord, that department itself pay compensation to me, my lord. On the other on the record, my lord, this police department who is claiming that allotted to me, my lord, allotted to them, subsequently seek allotment from the authority, my lord. That is matter of record, my lord. Now, my lord, coming back to my issue, my lord. Now, ultimately, revisional order, my lord. I challenge with WPC number 100 of 2019, my lord. Now, 19, my lord. Now, that order will be maintained. If my lord allow me to read the order passed in my lord, this, my lord, WPC number 100 of 2019, my lord. Categorical order was passed by this report, my lord. In terms of who is this, my lord, if I may allow to read, my lord, this page number that start from 26 read appeal, my lord.
Page 28, last paragraph.
Last part. 28, from the said point of view, we interfere with the said order dated such and such by the who is the Department of Punishment of withholding of 2 increment, 1 increment imposed on the petitioner. The consequent authority and dated and also it also stand interfere. The matter is remand back to the disciplinary authority to consider a press, my lord. That is the order. Consider a press whether the act of unauthorized occupying a plot of government land also amount to misconduct and indiscipline in service law. Depending on the conclusion, let me at the region order be passed by the disciplinary authority. However, it has been brought to the notice that the petitioner is unauthorized occupying a plot of land. The liberty would also remain on the respondent authority to proceed with the petition as per the law. Now, if I correctly understand this, my lord, this order has two parts: categorical order, my lord, directing a place, my lord, and second, my lord, to decide whether occupation of government land, my lord, will come under the definition of misconduct, my lord. That is the two parts. Now, in terms of that, my lord, this order was the impugn order I challenged in this particular case, my lord. That order, my lord, is at page number, my lord,
132.
132, my lord. Now, category order was passed to determine a place, my lord. Now, no proceeding was initiated, my lord. A place, my lord. This order was passed. Accordingly, this impugn order I challenge in WPC, my lord, from his who is this appeal arise, my lord, on two grounds, my lord. As direction of a place, my lord, that was not conducted. That itself would be the ground, my lord, to interfere with that impugn order, my lord. Impugn order dated at 26 May 2022, my lord. In the reason cited, my lord, no is nowhere in the rule book, my lord. So today, my lord, my humble submission, the issue before your lordship is, my lord, whether, my lord, the statutory pass, my lord, whether the statutory authority, my lord, acting under statute, gain, my lord, the order of the statutory authority, my lord, can be justified in terms of additional epidemic or by the submission of the council, my lord. That would have passed, my lord. The order of the any statutory authority, my lord, passed by my humble understanding, my lord, the order of the any statutory authority, my lord, should be tested from the body of the order, my lord. That cannot be justified by adding some submission in that the partner. Second, my lord, assuming whole allegation right, my lord, whether the any penal action, my lord, that has some consequence, penal consequence, my lord, whether that can be read to stress includes whole thing, my lord. My humble understanding, my lord, if authority is acting under some strict provision, my lord, now to bring a person under that provision, my lord, that should be precise, my lord, particularly in the rule like this departmental inquiry, my lord, has a penal consequence, my lord. Ultimately, that affecting the life life earning, my lord, like decreasing of two increment, my lord. To that extent, my lord, I'll place some judgment, my lord.
Citations.
This is, my lord, 2088 SCC 14141, my lord. For, my lord, the only one para I'm relying, my lord. Para 11, my lord. The learned counsel for the petitioner that thus had rightly drawn our attention to the constitutional judgment of this court in Mahindra Singh Gill versus Chief Election Commissioner to submit such a plea cannot be accepted.
Okay.
We mean
Okay, we got it. Next,
this one, my
Mahendra Singh Gill.
now, second, my lord, whether, my lord, this the provision having some penal consequences, my lord, can be written in such statement that bring all things in its supervision. The para I have indicated, by lord, the important para will be para 25, 28, 32, 34, similar to my case, my lord, in this case, the interpretation of this provision, my lord. They are trying to bring me, my lord, in this part at page number 55, my lord. They are trying to bring me in at willful insubordination or disobedience, whether alone or in combination with other, to any lawful and reasonable order of the superior. That they are trying to bring in. Whether, my lord, that can be allowed, my lord. Now, Supreme Court say, my lord, that's I'm start from page number 20, para 25, my lord. Rule for bearing the heading general general rule 5BR in the heading misconduct. The draftment of the 1975 rule made a clear distinction about the what would constitute misconduct. A general exception of certain decent behavior in respect of employee keeping in view cooperation culture may be moral or ethical expectation. Pillar to keep to such high standard of moral, ethical, or deciduous behavior be beating an officer of company by itself cannot consider misconduct unless the specific conduct falls in any of the enumerated misconduct in Rule 5. Any attempt to telescope Rule 4 and into Rule 5 must be looked upon with apprehension because Rule 4 is vague in a general nature and what is unbecoming of public servant may vary with individual and expose individual variety of subjective evaluation. What in a given context would constitute conduct unbecoming a public servant to be treated as a misconduct would expose a gray area not amenable to objective evaluation. Whether misconduct when proved entitled penal consequence, that my lord will can where misconduct when proved entitled penal consequence, it is obligatory on the employer to specify and it, if necessary, define it with precision and accuracy so that any ex post facto interpretation of such incident may not be complex as a misconduct. It is not necessary to relate on this point of view of recent decision of this honorable court in such and such, where this court has everything which is, my lord, everything which is required to be precise has to be precise with precision, and no argument can be entertained that something not prescribed can yet be taken into account as bearing in what is prescribed. In a short, it would be leave to the vagary of management to say ex post facto that some act of commission or commission who nowhere found to be enumerated in the relevant standing or in some not the less a misconduct that not strictly fall within the enumerated misconduct in relevant standing order, but yet a misconduct for the purpose of imposing a penalty. Rule 4.5 is still a general specific a norm of behavior, but doesn't specify that it violation is conduct and misconduct. In Rule 5, it is nowhere stated that anything violating Rule 4 would be as a misconduct in sub-clause Rule 5, which is specified misconduct. It would therefore appear that even if fake LS in two head of the charge are accepted as a whole proof, yet that would not constitute misconduct as prescribed in Rule 5, as no penalty can be imposed on such penalty. It may as well be mentioned that the Rule 25, which prescribes penalty, specifically provide that any of the penalty therein mentioned can be imposed on the employee for misconduct committed within Rule.
Mr.
So
Pramit, we have got it. We got your point.
Now, I'm relying to say that anything that particularly when some consequential now that should be precise, my lord. I would say, my lord, this there under this rule, my lord, there should be some civil dispute, my lord, between the to the employer, my lord, will come under the misconduct, my lord. Until and unless that is not precisely prescribed, my lord, this interpretation, as per the APS code, this requires strict interpretation, my lord. So my humble submission, my lord, not only under this clause, my lord, even if the at page number, even if they rely on this, my lord, rule, my lord, the under rule there is no from 1 to my lord 19 there is no provision, my lord, saying that, my lord, the civil dispute, my lord, with the employer will come under the definition of misconduct, my lord. Therefore, my lord, my act, my lord, to dispute having a civil dispute, my lord, cannot be in any time, my lord, can be brought into the definition of misconduct, my lord. So when my lord did itself, my lord, that initiation, my lord, of depravity inequality was on non-existent ground, my lord. This learned a single just matter, my lord, rightly interpreted the impine order, my lord.
Okay. Joseph, yeah,
And
that's one.
one, my lord, pardon, my lord, even, my lord, suppose, my lord, number 2 view, my lord, possible, my lord. As this is, my lord, not appeal, statutory appeal, my lord. This is appeal in principle, my lord. Even two view is possible, my lord. The my lord will surely appeal the view of the single bench, my lord. That I am remembering. Now, situation due to this department inquiry, my lord, since 2017, my lord, I have been deprived my right to promotion, my lord. Now, my junior already now. So therefore, my lord, my humble submission, my lord, the this case, this appeal need to be dismissed, my lord.
Lordship, just a small.
Yes,
Lordship, regarding the stain of the delinquent lawsuit, regarding the ownership of the present lane loss, how consistency he has been maintaining on that ownership, his stain on the ownership lawsuit. If lawsuit see the page 9 lawsuit, the first reply, when he stated that lawsuit, this land belongs to lawsuit the APPBN lawsuit allotted to, but since I'm in occupations of 1994, there's the one stain. And if lawsuit see the page 10 lawsuit, just I'd like to read this paragraph. This is the reply filed by the petitioner in response to, this is a written statement in response to memorandum of charges.
page 9 of repetition,
My additional,
read appeal,
additional affidavit lawsuit.
additional.
Yes, in read petition, what happened, lawsuit? They have they mix up the lawsuit first proceeding and second proceeding in the while filing the read petition lawsuit. So they have annexed lawsuit in not in sequence lawsuit. So therefore, it followed the read appeal also document. Therefore, I file additional affidavit lawsuit, where I have given the serial in seriatim lawsuit, the first proceeding, second proceeding lawsuit. Just I'd like to read the persistent what is taken lawsuit. Now it is this is his own lawsuit reply. Now it is also learned that your authority concerned had taken compensation from NH 52 road construction company, which your authority is no right to claim the land as the jurisdiction of land is falls under road construction company. Therefore, I am now being fighting with the land department, which the land in question belongs to me, because now land is falls under highway authority or land revenue department. Now say the lands belong to the, because land has been acquired, you have taken compensation. Now land belongs to highway or the land department. So this admitting that land belongs to highway or land department lawsuit here, because we have compensation has been given to us lawsuit.
No,
Yes,
my lord.
his stand lawsuit.
On the record, my lord, compensation I have taken.
I'm coming, lawsuit. Then lawsuit kindly come to page lawsuit. Next, what stand he has taken again lawsuit? Page 37 lawsuit.
Yes,
Page 37 lawsuit. Here lawsuit, this is again his own written statement lawsuit. That the undersigned begs to state that in regards with the so and so article label against charges. So the undersigned vehemently deny the acquisition and further state that in fact the land which is in question has been under peaceful possessions of the undersigned since year 1994 without any interference from any corner. Apart from that, undersigned had also developed pineapple, papaya, and bamboo garden on the said land, and further in pursuant to his cultivation on the said land, the undersigned had also been awarded with monetary compensation for assets grown on the land by the concerned highway constructing agency in the year 2013. Again, he said, he received the compensation.
That is supported
No,
by record, my lord, page 122 of the writ petition.
Let me complete. Then lawsuit kindly come to page 49 lawsuit. Page 49. Second paragraph, I'd like to read the second paragraph, where he says it was the no man's land lawsuit. That the undersigned begs to state that at the very inception during the period when undersigned was appointed as Lance Nayak in your concerned good esteem office, in as much as he was also totally unaware of the purported land allotment order number so and so issued in favor of your esteemed good office. Rather, the undersigned begs to state that initially the alleged plot of land was no man's land. As such, no one was in occupation upon the said plot of land. Thereafter, accordingly, the undersigned started his occupation. He said that no man's land. Then again come to page lawsuit 56 lawsuit. This is also his own lawsuit statement lawsuit. I'm taking lawsuit to page 57 lawsuit, relevant. paragraph 2, page 57 lordship. That I would like to inform you that in the year 1987, I purchased plot of land, land so and so, bordering with allotted so and so. So now he is again lordship developing from time to time lordship. He purchased plot nearby plot lordship, and this plot is lordship adjacent to that. This is how the lordship, the petitioner is changing his statement as to the ownership of the land lordship.
My lord, I humbly
Sir,
believe-
both of you. This plot of land, there is some payment made by the Zirat, payment made by the acquiring agency.
Acquiring agency.
He received it, that is in the earlier proceeding.
Lordship.
Now, if that land Zirat is paid, that means the land has been taken away. How come it is still in occupation with him? A part of the
It's a
land.
part of the land.
Part.
It gone in between from the.
Okay,
my lord, my lord, I humbly, this is not the appropriate, this title, my stain, my lord, this is.
Or Mr. Estapin, learned counsel for the appellant, then Mr. L. Carney for the respondent. Arguments concluded, judgment is adjourned.
May I also, I may be allowed to mention on a listing for on Monday, 16th, for
DB matter.
DB matters.
no.
Okay.
Your lordship, I may be allowed to withdraw item number 8.
Item number,
8, your lordship.
yes,
The parties have settled the matter after.
your good name,
Idakbam, your lordship.
pardon?
Idakbam, Aiba.
Ibam, Mr. Ibam, learned counsel for the petitioner. Submits that he has the instruction to withdraw this petition. Where is accordingly allowed? This WPC stands dispose of on withdrawal. However, liberty,
Your lordship.
no,
They have already settled the matter. Your lordship.
settle, okay.
Hello, my lord.
My privilege, lordship, my lord. As we have, I've already indicated last time, my lord, this is matter, though matter is very small, lordship. The only premise on which the writ petitions have been filed is that, my lord, the case of Uma Devi, my lord, lordship is as per paragraph 55, my lord, it should be applicable to the petitioners. Now, in the case of, my lord, first item, the lordship will just, it's a very small petition, lordship. We'll kindly see annexure 1, page 14, ma'am.
Page
14, 1/4, lordship. Petitioners at serial number 9.
Page number 14 of the writ petition.
Yes, lordship.
Yes,
Well, lordship will see the petitioner serial number 9, Kamtabya. And his casual lineman, lord.
Kamtabya.
Yes. And date of appointment is 1/10/1993.
1/10/1994.
Yes, lordship.
1903.
93. So this is the fact, ma'am. What happened, lordship will is the Arunachal Pradesh, ma'am, this is a casual appointment, my lord. Now he has been made as a skilled linesman, my lord. Because, my lord, when there was appointment, there was, I admit to do it that, my lord, there was no recruitment process as such. In the state of Arunachal Pradesh, I have never seen that for appointment of casual employees, there would be a recruitment process. All the appointments in Arunachal Pradesh are made in this way. especially which pertains to uh, casual employment. Therefore, what we are submitting is as per the paragraph 15 of the Umadevi case, Lordship, the case of petitioner should be considered. Now to this, Mala, the government has filed elaborate affidavit in opposition. Mala. First of all, what they contend is that there is a regulatory
So,
scheme.
what is your pair in this petition?
Lordship will kindly say,
Paragraph number 12,
yes,
page number 12.
yes, page 12. Case petitioner for regularization petitioner casual service as one-time measure in terms of the Umadevi.
Now
Also,
he has been working as skill lineman.
yes, since 1993, 110,
No,
1993.
no. Earlier he was casual lineman.
Casual man.
Since when he has been working as a skill lineman?
Mala, the affidavit. Additional affidavit. Petitioner by additional. Revision, let me check. Revision, let me check. Malad, that exact date, Malad, it's not there in our affidavit, Malad. Though we have filed additional affidavit showing that, Malad, the posts were vacant.
How many posts are lying vacant?
Your Lordship will, if additional, even the government has filed, Malad. The additional affidavit filed the respondents. Additional affidavit filed by the respondents.
By respondent number?
Respondent number, Malad,
2, 3, and 4.
2, 3, and 4.
2, 3, and 4. Yes, Mr. Parme, how many posts are lying vacant?
No, there is no vacant post, my lord.
The-
We have a regulatory scheme, my lord. Whenever vacant arise, my lord, on basis of their seniority, my lord, we
No,
fill
but
up
I'm
that, my lord.
thinking, those, the affidavit, additional affidavit which they have filed, they have said these were the vacant posts, my lord. And according to them, well, that's why I'm coming to the stand of the respondent. But they say we have filled up this post through regulatory scheme, my lord. Now the regulatory scheme which they have adopted, my lord, this is not in consonance with the direction passed in the Umadevi case, my lord. So that regulatory scheme would not apply to us. Malad, that is not.
If there is no post, how they will?
No, my lord, kindly receive. The respondents cannot now say that there was no sanctioned post, my lord. Since 1993, without break, every year the government sends amount, my lord, for these posts. Otherwise, how they will continue till 2024, my lord, if there was no sanctioned post. This honorable court in Supreme Court has said, this post doesn't fall from the sky, my lord. If there was no sanction, how they would have been continued, man? 1992 to 2024, man. That's then they cannot take.
These are not sanctioned posts. Is it?
No, man. No, that is, my lord, may kindly appreciate, my lord, how a person can be accommodated in a post, my lord, unless there is a sanction.
No, there is no sanctioned post, sir. Therefore, they are casual employee, casual lineman. Had there been sanction post, then they would have been regular.
My lord, definitely that stand, my lord, I understand government will definitely take stand. Because there's a no sanction post, that's why they are casual employees, my lord. Even for casual employees, the sanction comes, my lord. For this particular, my lord, for Chokidar, unless a sanction comes, how they will be accommodated? It's very simple to verbally say there was no sanction post and the appointment was not regular.
Regular sanction post, then this casual post, these are different.
Unless otherwise, how it would have been continued for 1993, my lord. It would not have, there should have been at least a break somewhere. Somewhere at least for 1 month, 2 months, if there was a break, I would have understood, my lord. That there was no sanction post, there was no money sanctioned by the government for this post. That is not the case. Therefore, your lordship, I'll leave it to your lordship, but definitely, my lord, this honorable court has already
But
in a similar.
Umadevi's ratio cannot be interpreted in that way.
No. I'll come to other judgments of this apex court also, my lord. What the Uma Devi says is, my lord, your lordship, I need not cite that one again and again, my lord. In case of, because the facts are very small, my lord. I have just shown, my lord, that they have been appointed in 1993 and they have continued to work, my lord, as a casual employee in that category, my lord. Now, your lordship will, I'll just place ML Kesari's case, my lord. One by one. Huh? Para 7 to 10, lordship.
Yes.
Mala, after Uma Devi also, Mala, this apex court has said, Mala. The para 7, Mala. It is evident from the above that there is an exception to the general principle against regularization enunciated in Uma Devi if the following conditions are fulfilled, Mala. That the employee concerned should have worked for 10 years or more in duly sanctioned posts without the benefit or protection of the interim order of the court or tribunal. In other words, the state government or its instrument should have employed the employee and continued him service voluntarily and continuously for more than 10 years. Well, there are two, that one, my lord. First, it says, my lord, it should be worked 10 years in a sanctioned post without the benefit or protection of the interim order or any court tribunal. In other words, my lord, next, the state government or in its instrumentality should have employed the employee and continued him in service voluntarily and continually for more than 10 years. The second is the appointment of such employee should not be illegal, even if irregular. Where the appointments are not made or continued against sanctions posts or where the persons appointed do not possess the prescribed minimum qualification, the appointment will be considered to be illegal. This wouldn't apply, madam. It's not the case that we did not have the minimum qualification. But that the person.
Your name is at serial number
9.
9.
Yes.
And Mr. Parme, when the regularization process starts in a year, particular year.
No, my lord, whenever things this vacant some vacant post arise in WC my lord, category.
So how many vacant? How many posts are vacant now?
Now that in affidavit I have, if my lord kindly look, there is no vacant post. Yes, now my lord, my additional affidavit. I have indicated, my lord. My lord, kindly turn to page number 6, my lord.
Page number?
Page number 2 will be better, my lord. Page number 2, my lord. 2, my
Yes.
lord. The deponent, para 3, my lord.
So
The-
when you have filed this affidavit? In the year 21?
21, my lord. In terms of dishonorable conduct, I have filed my lord. Yes.
No, AO obtained instruction, AO informed this court of how many posts are lying vacant.
No, my lord.
Definitely some posts are lying vacant
My lord,
since the 2021.
if my lord allow me to read this, my lord, I'll explain it, my lord.
Which one?
Para 3, my lord. Para 3, my lord. Para 3, page number 2, my lord. The deponent beg to submit that as per the written instruction received from the
Which affidavit?
this is addition by the additional epidemic by the respondent, my lord.
Respondent number?
In respondent not respond in term of court, this honorable court order dated 25 to 2021, my lord. In term of 25 to 2021, we have filed this, my lord. 25 to 2.
Yes.
Para 3, my lord.
Hmm.
The deponent beg to submit as per written instruction received from the executive engineer SEPA. There are 67 sanctioned posts of WBC SARS under SEPA executive division. Department of Power. Out of 9 WC staff of the following designated posts were fallen vacant during 2016 and 19 due to retirement, expiry,
No,
promotion.
this, paragraph number 3 indicates that Khalasi wireman 5 posts, Khalasi lineman 2 posts, Khalasi handyman 1 post, Khalasi meter reader 1 post.
Yes,
Page
my lord.
number 2.
That's why, my lord, if this para, we have made a category estimate para 7, my lord. Suppose in term of petitioner number 7, my lord, page number 4, my lord. The department beg to submit.
No, this affidavit is also dated 3rd of April 2021. Since then, you have not filled up any post.
No, my lord.
Not filled up. Definitely some posts are lying vacant. You
Yeah.
obtain instruction and inform
The
this court.
process is, my lord, we have a regulatory scheme, my lord. My lord, if you recall, my lord, the while sitting in division base, my lord, already tested that, my lord, regulatory scheme, my lord. Already, my lord have already seen that, my lord, while sitting in a division bench with Justice, retired Justice Bujjar Barua, my lord. My lord, I correct. Now, we have a regulatory scheme, my lord, in Arunachal, my lord. For this this particular class of person employee, my lord. Now, in terms of the regulatory scheme, my lord, that is like a recruitment rule, my lord, who is provide, my lord, whenever now in case of SEPA, there are 67 sanction posts under SEPA division, my lord. Now, whenever vacant post arise, my lord, in terms of seniority, my lord, the person will be called for DPC, my lord. DPC, my lord, they will be interviewed, my lord, and in terms of their eligibility and seniority, my lord, they will be appointed, my lord. Now, there is scheme, there is this is not like that, my lord. We have no scheme in place, my lord.
I am not asking you about the scheme.
My lord.
You inform me how many posts are lying vacant as on today.
For that, my lord,
You obtain verbal instruction after 1 hour. You inform this court.
my lord. Today, my lord.
Your lordship, I have brought the judgment. Your lordship, lordships have passed the order, man. That the regularity scheme is totally different, man. This came before the Uma Devi case, man. It's so something totally regularizing the employment. It's not in terms of that order. They have not framed any rules and regulations in terms of that order. Therefore, what we are praying in this repetition is that, my lord, in terms of that order, my lord, we should be regularized. That's the case. All those regulatory schemes and all that.
Let him obtain instruction.
Yes, sir.
We'll see.
Item number 4, which is the main writ petition, the first writ petition, may be taken up first, my lord.
Petition number 328.
321.
Okay.
This was the first writ petition which was filed. And my lord, my only some additional submissions to be made is before Mr. Tagum makes his reply, to the query of the lordship. But this, the petitioner and those who has been regularized are similarly situated. The total vacancy was 17, but the department has projected only 16. They have missed out one post, which in their file, they have categorically admitted that there was a one vacancy. So in that continuation, Malad, since we are all similarly situated, Malad, I just want to make a one small this thing, and it's 2006 2 SCC, page 747. I'll take you to just on the principle only, Malad. Similarly situated persons should be treated equally, Malad. Only 2 lines, Malad. Paragraph 29. Only the first 2 lines, Malad. Service prudence evolved by this court from time to time postulates that all persons similarly situated should be treated similarly, Malad. Malad, your lordship has also passed this orders in this only for just to highlight the principles in underlying this, Malad. Now, Malad, secondly, Malad, this is a basic is this is a scheme evolved by the Union Ministry of Health and Department of Health of Government of Arunachal Pradesh. Now, schemes are still continuing. My lord, in my reply affidavit opposition, reply to the opposition, I have annexed that continuation of the schemes. So, my lord, annex 12 at page 84 of my reply affidavit. So, my lord, just to show that the scheme is still continuing, the government of Arunachal and the government of Union of India, Ministry of Health, they are continuing to build up a robust health sector. So, my lord, lordship, I have the other day I have submitted
Yes.
the other day I have submitted judgment by your lordship, where in earlier case, in previous case, the same situation, one post was missed out, and one Dr. Menbom Miji, he had filed a writ petition, and there was a direction, one-time election should be provided, and accordingly he has been appointed. My lord, in these petitions, I have not annexed that copy of that order, but in the second writ petitions, I have annexed the appointment letter of Dr. Minbom Miji, my lord. My lord, I have just provided the type copy of the same order on the last.
Yes, yes.
Yes, my lord. The point number 10, my lord, he has been given the retrospective benefits all. Those who with all those other similarly situated persons, my lord. So my prayer in this item number 3 and 4 is that I should be regularized with effect from those 16 persons who has been regularized, and I should be provided with all the benefits which they have got. This is in item number 3 and 4, Malad. Then I have 3 and 4. Mainly in item number 4, Malad. Item number 4 is the main writ petition. Then I have this 6 and 7. 5 is, I think, yours. You'll make submission, or should I make? No. I mean, no, 6, 7, 30. But in item number 6 and 7,
Hmm.
these are also the same contextual service.
Hmm.
The genesis of all these three cases are the same, but slight variation. But in item number 6, but number 5, he will argue after I complete. But here, may I just take your lordship to the annexers, my lord, of the writ petitions. Which item? Of the writ petitions, my lord. Page 22. Lord, I go back a little bit further back. Lord, in 2009, 15 contextual dental surgeons were recruited. And my lord, in all these things, these are based on selection process.
Hmm.
Because this is a central government and national government combined scheme. So there was a selection process in all these three cases. In fact, in all these other cases also.
Hmm.
My lord, page 22, my lord.
Yes.
This page 22, this was in 2009, my lord, order.
Hmm.
My lord, 15, my lord, here serial number 15 is important because this is where while regularizing, he was missed out. Number 15, Dr. Menbom Miji. Out of this 15, one did not join. So there were 14 were recruited. In fact, 14 joined. Now, my lord, after this, at page 24, since the intention was to build up a robust health sector, the government of Arunachal Pradesh has adopted a health policy, my lord.
Hmm.
Page 24, my lord. Page 24. My lord, at page 25, I have accepted only the one clause 20. My lord, that pertains to the regularization. My lord, may I read, my lord? It is further proposed to regularize the officers and staffs appointed under NRHM as per availability of sanctioned post and seniority. Now, my lord, page 26 and 27 are also the same. Now, my lord, at page 28, this is a regularization order, 3rd April 2012.
Hmm.
Is pleased to regularize the service of 13 contextual medical officers, my lord, here. Now, here, as I have submitted, there were, out of this annexer 1, the 15 appointees, one did not join. So I became number 14. So here they have regularized only 13 sanction posts, 13 posts. Now I was left out. Now we have found that there was a vacancy during this period.
Hmm.
So this Menbom Miji had filed a writ petitions as your lordship has perused in the earlier case. And at page 30 is the appointment letter. And the type copy which I have furnished to your lordship is page 32. Typed copy. May I just take your lordship to page 33? Because out of this serial number 10 is important, Malad. May I read, Malad? The interstate seniority shall be counted as per seniority with a reference to date of appointment and joining in the NRMGM. And in case the date of appointment and joining duty day coincide, then the seniority in S shall count. The date of regularization of his service along with financial benefits will be with retrospective effects. This is from the date of 13 other doctors who were regularized on 3rd April 2012, Malad. So, my lord, in this case, he was appointed with retrospective benefits, my lord. Now, my lord, coming back to the present writ petitioners, Annexure 5, my lord, at page 34. Annexure 5, page 34. My lord, our name appears from serial number 7 onwards, 7, 8, 9, 10, 11, 12. And my lord, at page 37 also, serial number 1 and 2. Out of this, my lord,
30, next page.
page 37. Type copies, page 39, my lord. These are the appointment letters on contextual basis. Now, there are 7 writ petitioners. 5 names appears at page number 34 and 2 appears at serial number 37, my lord. Now, my lord, the same seniority list, page 40, my lord. Page 40, next page, my lord. My lord, this seniority position was reflected in the serial number, case number 3 and 4 also. My lord, here at your lordship may kindly come to pay, serial number 17. 17 is that earlier writ petitioner. From 18 onwards to 32. Out of this, one person has resigned. Another person he also did not continue. Serial number 19 to and 28, they are not here. So, my lord, our name appears at serial number 18, 20, 21, 22, 23, 24, and 25. Up to 25, my lord. Serial number 21 is the first writ petitioner. Then thereafter, from 18, continue, except this Mr. Serial person at serial number 19. Now, my lord, at page 8, is the regularization order of 16 GDMOs, which is also annexed in serial number 3 and 4, my lord. This is just to show that our similarly situated persons, they have been regularized based on the seniority and vacancy position, my lord. Then, my lord, Annexure 9 is our representations. Then at page 46, because there has been lot many such types of appointment based on the schemes. So the government has, by virtue of a cabinet decision, my lord, may I read, my lord, this order? Because this is order is page number 46.
Yes.
Order. In pursuance of the cabinet decision that the 21/5.
The other day, I
My
have
lord,
asked
Yes,
Mr.
yes.
Sagam whether this committee is presently in existence or not.
My lord, it is there, my lord. My lord, all the regularization is done through this committee. Committee their duty is to examine the financial position of post-sanction and everything, my lord. The department, as a health department, we don't have authority at all, my lord. We have specifically stated. Even the initiated a file that has been turned down by the admissive reform, my lord. And the admissive reform is the secretary, administrative reform is the member secretary in the committee, my lord. They have not been made a party, my lord. In case my lord's order passed, my lord, the ultimate they are the authority who is to comply this order, my lord. We have no authority, my lord. Now we have specifically stated in our affidavit, my lord. In all cases, the pleading is same, my lord.
In para 7, we specifically stated that we initiated for regulation, but the administrative reform they have turned down, my lord. Now, the administrative reform is the member secretary in the committee. They are not before this honorable court as a party. That's why in another day, my lord, I've been praying, my lord, please let this, at least one of the member, then be at least the party before this court, my lord, in this case. Otherwise, how the order will be carried out, my lord? It will be like air, my lord. We don't have authority. We stated, my lord. We initiated, and this now, that also we.
Now, first tell me, is there any vacancy?
My lord, it's not there, my lord. Because vacancy, whatever vacancy available that has been on requisition, my lord, the APCS, they have advertised, my lord. Before advertised, we initiated for regulation, my lord, through process, but administrative reform has turned down. APCS and administrative reform, because that is a criteria, mandatory provision under recruitment rule, even to relax this recruitment rule, for by invoking rule 16, my lord. The consultation with the APCS commission is required, madam. In accordance with the rule, when we initiated a file that has been turned down by the board APCS as well as administrative reform, madam. Administrative reform is the member secretary in the screening committee for regulation, madam. So that's why their presence is at most necessary, my lord. Because it will be passing order on air, my lord, in their absence, my lord, which cannot be carried out. Therefore, their presence is necessary, my lord. Without their presence, my lord, it will be very difficult, my lord. Because we have categorically stated in all the cases, my lord. We have initiated, we have tried our best. Even before the post is filled up by the APCS, through APCS, we initiated for regulation of their regulation, but that has been turned down by the administrative reform.
My lord,
Who is the member secretary in the committee, my lord? And we are not, the health department is not even member in the regulation committee. It is headed by the chief secretary as a
APC
chairman.
has already started a recruitment process,
But that has already filled up, completed, my lord.
completed.
Yes, my lord. All the available posts that have been filled up through APCS, my lord. Now,
Why don't
even-
you challenge the recruitment process then? Earlier,
my lord, to be very frank, they were also slightly late in approaching lordship. My lord,
what to do? If
my lord, may,
there is no
may,
vacancy now,
yes,
if the-
my lord, may I just make my submission fully? My lord, what had happened is this committee was constituted, but then, my lord, your lordship will kindly come to page 49. 49, page 49, my lord. This is dated 13 to 2024. 13 to 2024. The vacancy position is shown as 9.
and when the APC,
APPSC,
has started recruitment process?
it was dated 8 August 2024. Subsequent to this. Now, my lord, my respectful submission here is,
Then you could have made a prayer before this court that this process would be stalled.
we have made our this thing, but then it was not considered.
If there is no vacancy, if the that committee is not before this court, not before this court as a party, what to do then?
My lord, in fact, prayer number 1 was for quashing of this advertisement.
But let them get implemented those parts. That is utmost, if in an effective order has to be passed, there has to be there, my lord. Because even sanctioning position, financial concurrence, everything they have looked into, my lord. Even for creation also, they are the ultimate authority, my lord. Government have given them by way of cabinet decision, my lord. We have no authority after this 21 order, my 2021 order.
Now, my lord, here, that after that, I have filed a reply affidavit to the affidavit they have filed. Before that, my lord, my submission is, another submission is, because this vacancy position were in written shown on 13 to 2024. And in fact, this has arisen earlier than that.
Now you tell me whether you have participated in the selection process.
No, because we have already overage. Already 10 years, we have already rendered 10 years of service. We have already over advertisement, it is at page 57, age limit is mentioned as 35 only. We have all cross
The
35.
selection process is over,
Over, my lord, even filled up, my lord.
filled up.
Yes, now that is why, my lord, all those things to be looked into by the committee, my lord. Over age, for that purpose, only this committee has been constituted by the government, my lord. They are the ultimate authority, my lord. Therefore, even if there's a requirement of the other creation of post, they are the one, my lord.
Malad, let me, Malad, that in this case, we have filed our reply affidavit. Your Lordship may kindly take up my affidavit in reply.
My lord, the reply affidavit will not cure that problem, my lord. That is, we say that we specifically, even we
My
stated
Lord,
that. we
my
tried.
another submission is, Air Department did not reject our case. I have that, I have annexed that copy. And secondly, this committee is not a permanent body.
But
This committee is constituted only for the purpose of a particular act for consideration of the contractual regularization. So therefore, when this,
No,
My lord.
Mr. Partin.
yes, madam.
He is the council, he is the best person to appraise this court as to whether the committee is in existence or not. Today, he
Yes.
submits that the committee is in existence and it is the apex body to look after all the issues.
But in
So
that case,
let the member secretary be a party.
My lord, that is utmost, my lord. And what's the harm for harm in pleading, my
Partin,
lord?
you see, the recruitment process has already completed, vacancies were filled up, and there is no stay order of this court.
that is why this Uma Devi's case, principles Uma Devi's case will apply this case.
Uma
Now,
Devi's
in that
case,
case, my lord, I maybe the chief secretary and this committee may be permitted to be implemented as a party respondent in 6 and 7. My lord.
no, in all the cases,
Yeah, all the
My
cases,
lord,
my lord, all
in
the
3
cases.
and 4, it's not required. My lord, there is vacancy. There is an interim order by your
But
lordship.
even then also, my lord, this even if existing, there's a vacancy also, my lord, that ultimate final call is to be made by this committee, madam. We cannot
No, my
supersede
lord.
it, my lord. Now,
My
here,
lord,
my lord,
this is
even
question of-
contingency staff, my lord. That is to be, now that has been streamlined, my lord. There's a committee is compulsory, my lord. Even contingency staff, my lord, even they are required to, if it's they're supposed to be regularized, that is to be looked into by this committee. Only its approval, my lord, can be done.
anything, everything will go to that committee.
My lord,
No,
my
my
lord.
lord. This because in that earlier case, since there is a vacant reserved by this
No,
honorable
that's all
court
right.
order.
Even without approval of this committee, no appointment can be made, no
Exactly.
regularization can be made. Even that order has also to be, also has to go to the committee.
My lord.
But in earlier case, this Dr. Menmo Mij's case, this was done by the Department of Health and Family. Your lordship may kindly come to page 32 of my writ petitions.
That was
Prior to this, my lord.
before this committee.
2013, my lord. This was prior to this cabinet. The cabinet decision has taken, my lord, streamlined. Everything was taken care of by this committee now, my lord. We don't have authority. Even to that effect, we have stated, my lord.
You implement the member secretary of the committee as
lord.
respondent number.
3, my lord.
Respondent number 4.
Yes. In this case, my lord.
Yes, Mr. Opang, what is your submission?
Lordship, I am just conducting the examination authority. I have nothing to say in this.
Lordship, I'm in respondent amendment 5. My contention here is, I will just rely on small judgment of the Supreme Court, where it clearly says that the policy circular, whatever is with the government, in such policy and circular, they cannot act pick and choose. Same issue that we are facing right now. The issue that arose for consideration before the High Court was whether the respondent one was entitled to be observed as a regular employee. It may include that the government policy circular and the long period of service rendered by him as a daily visit. The High Court held that respondent number 1 was entitled to regularization of the service
Several person near to him had already been absorbed.
No,
But
they
what-
were a casual employee,
Person here also we are.
daily on daily wage basis. You are not casual employee.
Similar situated case.
No.
We can say
So, grade 4 post and this gazetted post are different. So for filling up the gazetted post, so it should be routed to the APSC. You cannot get benefit of this judgment.
Paragraph 5.
Let him also get in play this committee member secretary, my lord, as a party man.
So how many doctors are working as working on contextual basis, Mr. Patil?
In this case,
Only 7.
only read petitioner are seven because there are, I think, some more doctors are there.
And that is why, my lord, in department wise, my lord, these the committee will look into, my lord. If they are required to be regularized, my lord, they will see the financial position, concurrence, and the sanction post.
Let the committee be implemented. Thereafter we'll see.
My lord. That will be the safest, my lord, for them also, my lord. Because if other pass, we cannot implement, my lord, and we are not the authority to implement the order, my lord.
And the petitioners are also they contractual. They are working in contractual basis and they are casual also. But they could have file a red petition mass earlier before this.
I agree, Bharat.
Before formation of this committee. Then even the recruitment rule is adopted, then the department has to follow the
Rule, my lord.
rule.
Otherwise, Bharat, before, instead of dragging these matters at length, Bharat, since there are since this petition committee is already existing, your lordship can direct the committee to consider all the matters along with the other matters within the time
We'll
frame.
direct, let him appear. Let the member secretary appear before the court. Thereafter, we'll consider your prayer.
Well,
Heard Mr. T. Patil, learned counsel for the petitioner. Mr. A. Apang, learned senior advocate, assisted by Mr. Learned counsel for the respondent number 3 and Mr. Tagum for respondent number
1 and 2, my lord.
1 and 2. Pursuant to order of this court dated 10/12/2024, Mr. Tagum, learned standing counsel for the respondent number 1 and 2, obtained necessary instruction in respect of the existence of the committee.
Formed on 1st July 2021.
Committee constituted by order dated 1st of July 2021.
Relating to absorption regularization
For-
services.
For examination of all the cases relating to absorption, regularization of services, which we make it as a one-time measure. All those employees who are working on temporary, contractual, contingency basis, etc. basis, in various government departments. Person to the cabinet decision dated 21/5/2021. How is that the line? Then apprise this court that the committee is still in existence and it is the apex body to consider all the matters relating to absorption, regularization of service of the employees who were working on temporary stroke contractual stroke contingency basis in various government departments. And in order to adjudicate the dispute raised in these petitions, the member secretary of the said committee, who is the secretary of Administrative Reform Department, has to be arrayed as respondent number 4. Respondent number 4 in this petition, and accordingly, taking note of the submission of Mr. Tagum, learned counsel for the standing counsel for the respondent number 1 and 2, and also considering the submission of Mr. Patil, learned counsel for the petitioner, it is provided that the member secretary of the Administrative Reform Department, who is the member secretary of the secretary to the Administrative Reform Department, who is the member secretary to the committee, said committee, constituted by order dated 1st of July 2021, shall be arrayed as respondent number 4 in this petition. Let notice be issued to the newly implemented respondent number 4.
My lord. My lord, the government will, my lord,
Oh.
take notice. Senior government
Oh.
advocate, my lord.
Amu,
As Mr. P. Pango, learned junior government advocate, present and received notice on behalf of and agreed to receive notice on behalf of the member secretary of the said committee. No formal notice is required to be issued. However, extra requisite copy of the petition be furnished to her within 2 days from today.
2 days.
2 days from today. List the matter before vacation then?
Yes,
My
my
lord.
lord.
uh,
18, my lord.
18.
18 December.
18.
Within my lord, endeavor shall be made to dispose of it within that observation.
Let them bring inside.
Same ordered in item number 5. CP 91.
5. Item number 5.
3, 4, 5, 6, and 7. Obliged, Lord.
And my lord, part hard, it may be discharged, my lord.
Ah,
That it
The
is,
matter, all these matters may be released from the part.
my lord.
Your Lordship, we have not received this one, petition, Your Lordship.
Today, they will furnish within 2 days from today. Madam, you obtain instruction and place it before this court on next day.
Ma'am, please. My lord, this is the matter on which last occasion, my lord, the LCR called for.
Yes.
My lord, even,
Madam, is there?
yes, my lord, I am informed that yes, LCR has been issued by the council for the state.
Receipt.
Yes, my lord. Even before, my lord, the proceedings to, my lord, the perusing the, my lord, the original report of the, my lord, the department. However, my lord, My only contention, my lord, that aspect, my lord, the first, basically on two aspects, my lord. One is, my lord, I'm not the only responsible persons for, my lord, the escaping of the, my lord, duty fees, my lord, from the sale. Of course, I was on the duty, my lord, above me, so many officers, man. They were engaged, and as per their findings, there was no any, my lord, the kind of, my lord, negligence. The age is, my lord, timely inspected by the inspector and the officers,
No,
office,
after the disciplinary proceeding, you have filed an appeal before the authority,
My lord.
appellate authority.
yes, ma'am.
And what is the view of that authority?
My lord, only they uphold the decisions of the, my lord, the disciplinary authority.
Disciplinary
My lord,
authority.
that extent, my lord, without giving any, my lord, I have enclosed the entire, my lord.
Yes, so on the other day, madam, you received the file?
Yes, Lordship.
You received the file, and I was asking about the statement of one witness particularly.
Yes, yes,
Some Sharma.
Yes,
Yes.
It is available there.
yes, Lordship.
Uh, can you show me the statement?
The pink flag one.
Yes.
My lord.
Also, from the beginning, the inmate knew that he was Lordship escaping, but then he was threatened, so he could not Lordship tell the authority also.
Now, what is the point of your challenge of the this report of the disciplinary authority?
My lord, challenge is, my lord, the Sokos notice, my lord, after the preliminary inquiry, my lord, Sokos notice was issued to me, and wherein I have replied the, my lord, the Sokos
So,
notice,
is there any infirmity in the disciplinary proceeding?
my lord. The infirmity is, my lord, that part, my lord, to that extent, my lord, cutting of the, my lord, the iron rod is not a, my lord, my lord, my lord, the easy work, even if, my lord, the facilitated, my lord.
No, well, that is factual aspect we will look into.
My
But
lord.
you tell
Now,
me.
my lord, to that extent, my lord, my lord, inquiry was not conducted, my lord. Facilitated, even if the, my lord, higher authority, my lord, even if, my lord, I was posted as, my lord, the duty in charge, my lord, at that relevant point of
No,
time.
you tell me what are the points you are challenging the report, inquiry report?
My lord, it is, as I have, my lord, given in my lord, grounds. First is, my lord, it is arbitrary and, my lord, the discrimination.
How?
my lord, since I'm not the only, my lord, even my lord, the escape, my lord, even facilitated, I'm not the only responsible persons for the escaping of the
No,
matter.
no, whether other persons are responsible or not, that is not our lookout.
My lord.
Our lookout is what was your rule?
My lord. My rule, my lord, is therefore, my lord, time and
What are
again,
the points you tell me?
my lord. First of all, my lord, the impugn order is, my lord, has been passed mechanically, my lord, arbitrarily.
Mechanically, how?
My lord, mechanically is because, my lord, as to that extent, my lord, there has not been given an opportunity to even, my lord,
What
cross-examine.
opportunity?
My lord, even cross-examination, my lord, this is as per the disciplinary, my lord, the proceedings. One, my lord, the witness has to be appointed by the, my lord, the charged delinquent officer, my lord, charged officer.
Mm.
Now, the charged personnel, my lord, particularly, Mr. my lord, Suraj Setri, he has to be provided one defense counsel, my lord, of his own or from the department. My lord. There has not
Whether you have made such made
no,
such
my lord, that
application.
opportunity was not given even.
No, whether you have filed any application to that effect that.
Admittedly, my lord, to that
No.
providing of the defense is, my lord, the or counsel that has not been given.
No,
Admittedly, my
no,
lord.
did you file any application?
No, my lord. Admittedly, no, we have not filed.
You
Even
have
that
not
has not
filed?
been asked. Even, my lord, that is unaware, totally unaware on the part of the, my lord. This is, my lord, the constable only, my lord, lowest grade staff of the, my lord, department. Even he does not know, my lord, how the proceeding has to be proceeded further.
Mm.
So therefore, that even if such is the position, my lord, that has to be provided by the department or the inquiry officer. If you want to engage, my lord, the witness or the defense counsel for your, my lord, the cross-examination. Even cross-examination has not been done, my lord. As per the procedure, my lord, even if, my lord, the witness is produced, and, my lord, the altogether, as per the proceedings, my lord, so many staffs were, my lord, examined by the disciplinary authority, my lord,
Mm.
inquiry authority. Now, my lord, none of them has been examined, my lord, cross-examined
Mm.
by the, my lord, the charged personnel,
Mm.
Sri Suraj Setri, my lord. So
Mm.
therefore, my lord, that is one another, my lord, aspect. My lord, this aspects, my lord, lordship may kindly peruse the preliminary, very preliminary, my lord, the report. First preliminary report,
No, preliminary report will not go.
my lord, wherein, my lord, the first hand information, my lord, has been ascertained, my lord. First information, my lord. This is the, my lord, the first preliminary in inquiry report, my lord, that has not been taken into consideration by the, my lord, the inquiry authority. Preliminary inquiry, the findings of the preliminary inquiry is something different, my lord, but that has not been taken into.
Maybe that inquiry is conducted only to ascertain whether departmental proceeding can be drawn against you or not.
Exactly, my lord. That is one of the prima facie, my lord, documents where finding is, my lord, the completely, my lord, different, my lord. My lord, that has not been at all taken into consideration
No,
while the
not
frame.
necessary, not necessary.
My lord. Inquiry report is, my lord, my respectful submission is, this is the first hand inquiry report, my lord, where, my lord, everything has been ascertained. Therefore, my lord, it is one of the, my lord, the vital documents, my lord, which has to be taken into consideration at the time of, my lord, the regular proceedings, my lord. That has not been at all, my lord, taken into
No,
consideration,
not necessary.
my lord. And, my lord, my defense, my lord, defense statement. In my defense statement, my lord, I have clearly stated that the all allegations leveled against me.
Pardon?
My lord, all the allegations leveled against me
Mm.
is basically, my lord, on the based on the, my lord, the other, my lord, the evidence, particularly, my lord, none of them, my lord, has disclosed. Altogether, my lord, 7 to 8, my lord, witnesses examined, my lord. And none of them has disclosed, my lord, anything, my lord. Now, my lord, another aspect is the other police personnel.
Are you submitting on the basis of record?
Yes, my lord. My lord, as per the findings, my lord, of the lordship may kindly peruse, my lord, the statement, my lord, the conclusion, my lord, first preliminary charge.
So,
My lord, when there is, my lord, the office, where there is a, my lord, the officer above me, the findings of the findings and the statements of the officers who were also, my lord, responsible for the sale, they deposed their statement that everything was okay, my lord. Then how, my lord, this personnel can be, my lord, personnel can my lord, helping in my lord, escaping of the UTP, my lord. Therefore, my lord, my respectful submission is when my lord, altogether, my lord, 6 to 7 police personnel were engaged and my lord, the duty officers for that particular UTP cell, then my lord, how my lord, I alone can be my lord, a persons to facilitate him for my lord, escaping of the UTP, my lord.
Okay. Okay.
Yes, my lord. So therefore, my lord, my lord, the findings of the my lord, the inquiry of authority, my lord, and the dismissal is my lord, 2 hours. My lord, there is another other provision, my lord. This is as per the rules, my lord. This is a major punishment, my lord. So therefore, my lord, I am claiming for the my lord, since I claim before the honorable my lord, the disciplinary authority for leniency for awarding of the punishments to that extent, my lord, not in measure, my lord. There are other options where the punishment can be awarded if, my lord, not the dismissal, my lord. Since it's because, my lord, I am not the only responsible, my lord. My repeated submission is
No.
yes, my lord.
That submission cannot be taken into account.
My lord. One, my lord, person cannot be held responsible for the entire episode which has been, my lord, taken responsible by the my lord, the so many officers above
Yes.
me, my lord.
Yes, madam, what is your submission?
My lord, another, my lord, aspect, my lord.
What?
As last occasion, my lord, I pointed out that my lord, disciplinary authority, my lord, as per the discipline, my lord, their rules, my lord, impugn order has been passed by them, my lord, my appellate authority, my lord. Constable was appointed by the appointing authority.
Then before whom you have preferred the appeal?
My lord, impugn order directly was passed by the appellate authority. My lordship will find the impugn order at page number, my lord, 11. Page number 63, annexure 11, sorry, my lord.
No. Then who passed the order on the appeal preferred by you?
Order, my lord, the
DIG.
DIG, my lord. No, my lord, Inspector General of Police, my lord. IGP, my lord. Second, my lord, on my appeal, my lord, order was passed by the IGP, my lord. Then I prepared again another appeal before the, my lord, the Director General of Police,
You have preferred two appeal.
my lord,
Two appeal.
2 appeal. Then, my lord, the Director General of Police, my lord, by impugn order dated, my lord, upheld the, my lord, the decisions of the first authority, my lord, 20th February 2028, my lord. This is the, my lord, the order of the appellate authority, my lord.
Yes, madam.
Lordship, may I, my lord, my lord, produce the, my lord, the disciplinary and
Appeal.
this appeal rules, my
rule.
lord. It says that, my lord, it says that the if appointed by the, my lord,
Rule. What is the rule?
rule, my lord, it is called Arunachal Pradesh
No, that's all right. You are referring to rule.
rule, my lord, Sidal. It is rule, my lord. Sidal of the, my lord, rules.
Pardon?
Sidal of the rule, my lord. Sidal.
Schedule.
Sidal of the rule, my lord. Hierarchy is given, my lord.
Okay.
Constable was appointed by the my lord, the Inspector General of Police or Superintendent of Police, my lord. My lord, my disciplinary authority is Assistant Inspector General or Superintendent, my lord. And my lord, my lord, appellate authority is Director General of Police, my lord. But in the very beginning, my lord, the order was passed by the Deputy Inspector General of Police, my lord. Whereas, my lord, it is
Okay,
by
we'll see.
my lord.
You give it to the
Yes, ma'am.
court master. Yes, madam.
This is the only my lord.
Lordship, I have provided the record also. It's very clear that the inquiry was done properly. He, against the order, he have gone for appeal, he have gone for revision also. Everything was taken care of. And then Lordship, he being in the disciplinary Lordship department force, Lordship, this is a Lordship. This is a Lordship punishment rightly given, Lordship. Because-
Rightly given.
Yes, Lordship, because he have Lordship felicitated Lordship in the statement also in by the his inmate Lordship who was staying with him, the Sarma, prisoner Sarma, who have given a statement Lordship against him. Lordship. He have facilitated the accused Lordship, Bungbetai, Lordship. And then uniform, even uniform was provided by him, Lordship. And he was the jailer of that cell, Lordship. It can be, Lordship, seen from every this one that he was the jailer of the cell, Lordship. So he had facilitated, he could not, Lordship, he had represented himself, but then in the representation, there is nothing, Lordship, that could be taken care of, Lordship. He have nothing, brought nothing new, Lordship. And then, Lordship, for the Lordship, the petitioner saying that the order has been passed by the appellate authority, Lordship, unless it is passed by the lower standard of the officer, Lordship. Higher, they can always, in the rule itself, is there higher, Lordship, they can pass, Lordship. It was not a case that there was no appellate authority. He have appeal, Lordship. There was appellate authority. That's why he have gone to appeal. It was properly disposed of, Lordship. Even the revision petition was disposed of, Lordship. And then for the proceedings that, Lordship, the petitioner is harping that proceedings has not been, Lordship, done properly, Lordship. For that, I have a Lordship ruling that the standard of proof in disciplinary proceedings, Lordship, is a preponderance of probabilities, Lordship. Lordship, I'll give one to Lordship, para 13, Lordship.
Okay.
Paragraph 13, Lordship.
1-3.
Yes, Lordship.
Heard Mr. M. Kato, learned counsel for the petitioner, and Madam Z.E.T., learned additional senior government advocate for the state respondent. Argument concluded, judgment reserved.
Madam. Madam, here major punishment is given, madam. The option of the major punishment.
Madam, this file will remain with me.
Yes, Lordship.
Deeply appreciated.
Yes, next item.
Item number 10. May I praise your lordship, my lord? And I'm from Guwahati, my lord.
This is the,
Number 10.
that case,
Only
wherein
my
while
lord, only,
returning from duty,
Acha, acha.
the constable met with an accident while returning from COVID duty. He met with an accident.
Hmm.
So
my lord, let me, my lord, let me apprise your lordship, my lord. Today is fixed only for,
On the other day, why we have agenda matter?
because
in order to apprise, my lord, whether he was declared as martyr or not. only to the extent they took time, my lord, to apprise the court. Whether the petitioner was, my lord, the deceased was declared as martyr.
Whether he has been declared as a martyr.
That is actually not the,
No,
not
the
the,
submission was advanced saying that he has been also declared as a martyr. Why he cannot be considered for this scheme, my lord, the benefit under the scheme?
No, this is not our submission. Our submission was that, my lord, while he was performing his duties and, my lord, in course of performing duties, he died of accident. They said that there is a distinction between duty and actual performance. He was allowed with the duties, my lord, to collect some information. And after collecting the information, when he was on the way to police station to, my lord, report his commanding officer, he died of accident. Therefore, they raised a question, my lord, he was not in performing duties. I have, my lord, cited a number of decisions saying that, my lord.
okay,
And
okay.
The only dispute here is whether he can be treated as on duty.
On duty or not?
Yes, as on
On COVID
employment.
duty.
Yes, or while performing duty, my lord. The only
my lord, argument was over, my
dispute.
lord. Argument was already over. Now he cannot, my lord, make any resubmission.
No, no,
So the
he's referring some judgments.
Yes.
My lord, our contention is simple, my lord. The scheme itself says while performing duty. And while performing duties, my lord, what are the eventualities? From the scheme itself, my lord, we see, if we go again to the scheme, my lord.
No, not necessary to go to the scheme.
So-
On the other day, we have seen it.
The scheme covers killed in military, this extremists, all this type of I'll just
He is repeating the
Make-
argument, my lord. The argument is already over.
I don't know why my learned senior is so excited.
No, question of excitement doesn't arise.
No, my lord.
Only for, my lord, asserting certain facts, whether he was declared as martyr and whether, my lord, any compensation was awarded to, my lord, to similarly situated person. These are the, my
Who
lord,
were
he
killed,
took time to appraise.
permanently disabled, grievously, seriously injured while performing duties, my lord. Performing law and order and disaster management duties, my lord. Here, while performing duties, what this is, of course, the last occasion also I have advanced, it's a beneficial legislation, but it is also a special legislation, special policy for certain contingencies. It will not cover all contingencies, my lord. It is a package is also of 50 lakhs. Why? Because of certain eventualities while performing certain duties, my lord. Now, since it's a special policy, my lord, giving higher ex gratia compensation, the role and the reason of the injury or death whatsoever has to be also in context with the duty performed by the person claiming. So here, although he was, the petitioner husband was deputed on duty for COVID, this duty, my lord, which is under the disaster management. But his death was caused not while performing the COVID duty. His death was caused while returning from duty in an accident, motor vehicle accident. And then, my lord, what I'm saying, it would have been a different situation.
Well, let me
Had
make
he,
it clear.
while
that, my lord,
performing duty, he has contacted the COVID and he got infected with COVID and died.
no.
That would
this is
have been
not-
a different situation.
Then-
Yes,
then-
we would have understood. Yes, while performing duty, he got
He was
infected
never
with COVID
allotted
and
with
then
any disease. COVID.
died, my lord.
Don't make
That
wrong
is-
submission.
No, Mr. Purkesta, please don't disturb.
So while performing that COVID duty, had he been infected or if he had been killed there while performing the duty, if he had been killed while performing the duty, that could have been a different situation. Being even infected while performing and then dying after 2-3 days also, that would have been a different situation. But the cause of death is not directly related to the duty assigned. The cause of death is while after performing the duty while returning back and meeting with an accident.
Okay, okay.
So, the last occasion, I have already submitted one judgment only. Then I'm placing one more. My lord, here also, my lord, it is the petitioner's husband.
On the other day, you have referred to 2018 judgment.
Yes, 2000. Yes, my lord. Punya Chutia. Because
Yes.
my lord will see on duty and whether on duty and while performing duty. It should be in action, killed in action, my lord. This one is, my lord, 2019, my lord. Kanchan Dua, my lord. Here also, it was the victim died of a cardiac arrest while he was posted in a operation, my lord, military operation. But that also has not been given.
Considered as on duty.
Yes, on duty.
Acha.
That also has not been considered. While he was on duty, he was placed on duty, madam. That also is not considered. That is the case. We have the thin line to
Yes.
distinguish, madam. Oblige, madam.
Okay. Heard, Mr. Anything, Mr. Purkesta?
My lord, so far as the last decision is concerned, my lord,
Yes.
my lord, he has made a submission that there is no any proximity of the duties which was assigned to him and the cause of death. To that extent, my lord, I have referred one decision, my lord. I'm just pointing out, my lord, serial number 15 of my compilation, my lord, para 6 and 7, and page 118 and 119 of the compilation. Logically have a, my lord, look it down. 118, 19 and 20.
Paragraph number?
In that case, my lord, I have serial number 15. Para 6 and 7. Para 6 and 7, page 119 and 120.
Okay.
In that case, my lord, proximity was discussed.
Okay. Okay.
With the nexus between the actual duties.
Purkesta, Learned Senior Counsel, assisted by Mr. Sharma, Learned Counsel for the petitioner, and Mr. N. Roton, Learned Additional Advocate General for the state respondent. Argument concluded. Judgment reserved.
Oblige.
Bless your lordship.
Yes, Mr. Tappan.
Lordship, in this case also I have very limited submission. If Lordship see the relevant rules, Lordship, that is Honorable Pradesh
No, Mr. Tappan, there is no doubt about the power.
power.
that has been given to the DGP.
Yes.
Now the question is whether he has exercised it in accordance with law or not,
Whether he is applied his mind.
mind or not.
Lordship, on that part, Lordship, just I'd like to take page 47, 45. Page 45 of the writ petition, Lordship.
Mm.
This is the impugned order.
Mm.
If inference can be drawn from here, Lordship, how the mind has been applied, that's only, this is the only the material, Lordship. May I read, Lordship?
No, he had directed for de novo inquiry. Is it permissible? De novo inquiry.
It's not de novo exactly, Lordship.
But you see the wording?
And the ode
Point
is,
number 2.
ode is there, Lordship. The order so and so is annulled. The de novo inquiry be conducted against Inspector Minlige and SI Susanja by Sri so and so, IPS so and so. From the evidence stage, Lordship. Not in the enterprise, Lordship. From the evidence stage, it is.
No, you see the wording of the line? De
De
novo inquiry.
novo inquiry is there, Lordship, but from the evidence stage, Lordship, it cannot be discarded, Lordship. It's not about the press inquiry, Lordship. Beginning from the punishing of memo of judges, Lordship. Because this, from evidence stage, it cannot be discarded, Lordship. This is the facts, Lordship. The use of the technical terms, Lordship.
Then why he had again appointed another inquiry officer? Inquiry officer, presenting officer. Is he entitled to? Is the disciplinary rule permits him?
Lordship, so far the competency of DGP to appoint inquiry officer, Lordship.
No, he's the appointing, no, so he's the appellate authority. He's the ultimate authority.
No, what I'm submitting is, Lordship, whether he is competent to appoint, Lordship, the inquiry officer or not, Lordship. That aspect, Lordship, I think it has not been raised in the writ petition, Lordship.
No, raise. On the day argued it was.
Actually,
So the question is whether in exercising the power given to him under Rule 31 of the APP, which in bracket D and A rules 1999,
Lordship.
he can appoint, he can order for de novo inquiry, he can appoint inquiry officer and presenting officer. The proper procedure ought to have been, there should have been one disagreement note. And that disagreement note ought to have been served upon him. And he ought to have been asked to submit his reply. And thereafter, the disciplinary authority or the appellate authority could have taken necessary decision. But here,
Apparently, that part has not been done, Lordship.
not there, not
But
there.
therefore, Lordship, I took Lordship to the page 45.
Hmm.
What was the mind behind this order? This is the only, Lordship, reason given on the top, past paragraph, Lordship. This is the only the mind on basis of which this impugned order has been passed, Lordship. Just I would like to may I read, Lordship. If anything is there, Lordship, then otherwise that part has not been done, Lordship. Admittedly, Lordship. But how the mind has been applied,
So
Lordship.
the thing is that, okay, he had applied his mind, but he has exceeded his jurisdiction, exceeded his power.
Here only, Lordship may appreciate, Lordship. This is two part, Lordship. One is annulling the Lordship, the Lordship particular findings, Lordship. That is one power, Lordship. Second, after annulment, Lordship, once annulment is held to be lordship correct lordship, then appointment of the press inquiry lordship officer, there's another aspect lordship. For this region lordship, this cannot be lordship held to be
That's why I have already stated you, he could have prepared one disagreement note.
lordship. So therefore, I was just taking lordship, what was the disagreement lordship? This paragraph, page 45, though, what was his mind lordship? How he disagree on the findings of the inquiry officer?
Yeah, that's all right. But this is not the procedure.
Okay, lordship, that admittedly lordship, that is jail. Admittedly, that is jail lordship. Just I was taking lordship to only the.
You tell me how this order will withstand the legal scrutiny. You tell me. Why should the court would not interfere? Why should not the court interfere with this order?
Lordship, if lordship see the rules lordship. Rules is lordship, silence lordship. Only the power has been given lordship. But the procedure lordship, how it has to be done lordship. That is not in the rule lordship. In the rule itself lordship, this asking the lordship official concern on the point of the disagreement lordship. These are not here in the, I think it's not in the rule lordship. It rule simply says lordship, what power is with you, the authority, the.
But in other service rules, in Assam, there is Assam Service and Discipline Rule 1969 or like that.
Lordship.
There it is provided.
I have not gone through that. It may be there lordship.
And definitely it may be in the CCS rule also. So while preparing the rule, definitely the authority has taken note of those rules, CCS rules or this.
But in this our rule also, Arunachal Pradesh police this rule, particular rule also. If lordship see the rule 31, the power of review lordship. Here lordship that procedure is not laid down how it has to be done, but only the power is given lordship. Power for lordship, what kind of power direction can be given? De novo or praise or lordship. Subject to the citation lordship on judgment passed by Honorable Supreme Court lordship. But one thing, what I can understand is the lordship. Basically, the service issues it always depends on the lordship governing rules lordship. Because it cadre to cadre, state to state, which rules govern to which cadre, and that rules is relevant. And judgment is always passed lordship basing on that rules lordship. Because rules is only the apply lordship. Here, definitely what lordship has pointed out lordship. That is lordship on page, it has not been done lordship. He was not asked on the point of disagreement. That is not there lordship. So
the thing is that this appointment of this inquiry officer by him,
this
he
is
should not have done it. You could have returned the matter to the disciplinary authority.
lordship, that part after break, just I'll take only 5 minutes lordship. After break.
5 minutes.
Only 5 minutes.
So you can continue, yes.
At 2 lordship.
No, you have to see the books.
Yeah, I have to see the.
Okay.
So apology for lordship.
No problem.
Inconvenience lordship.
No problem. Yes, next item.
Lordship,
break.
No, just one matter is there.
Okay.
Yes, Parme.
My lord, I'm informed that there is 4 vacant posts now, my lord.
4 vacancies, 4 vacant posts.
Mm,
Only 4.
4, my lord. Only 4, my lord. That this my lord trade is but different, my lord. One, my lord, WC electrician, one WC handyman, my lord. One WC Kalasi lineman, my lord. Lineman, my lord. One WC meter reader, my lord.
No, but is it believable that since 2021 only 4 posts become vacant?
Yes, my lord. I did post normally we have 67 sanction posts, my lord. Now, out of 67, whenever somebody retire, my lord,
Yes.
and somebody died, my lord, then in such situation only, my lord, post normally become vacant, my lord, until some new post is created, my lord.
You do one thing, you file an affidavit on this point. That only 4 posts are lying vacant.
My lord,
And against who is against whom
my lord.
you will see. But I don't believe that only 4 posts becomes vacant
My lord,
for the last 4 years.
my lord, that the categorical instruction I have received, my lord, from the authority, my lord.
That may not be the correct instruction. You place the written instruction and file affidavit.
It's it would be more than 5 years actually, madam.
Yes.
They,
Yes,
the
yes.
2021, they said regarding 16 and 19 that period.
Yes, yes, yes.
After that, I don't know.
Therefore,
Yes.
this instruction is not believable.
My brother can, I think, short affidavit can be filed based on the instruction.
My lord, for that, my lord, I look at time, my lord,
Oh, that's all right. You require time. I will grant you time.
my lord.
Not entire marathon, particular
But
duties
particular,
only.
my lord, particular, in form of particular mentioning, my lord, is a trait, my lord.
Heard Mr. Peter for learned counsel for the petitioner and Mr. L. Parme, learned counsel for the respondent.
Otherwise, my lord, my lord, for 2 minutes, if I may allow, my lord. Otherwise, my lord, I believe, my lord, whole this aspect, my lord, as my lord have already seen this in while sitting in division bench. All the issue, my lord, by the petitioner, my lord, has been dealt, my lord. In terms of division bench, we have constituted a committee also, my lord. Committee report is matter of record now, my lord. Now, in such a situation, where normally, my lord, the appropriate step would be to challenge that committee report, my lord. Until another committee report is challenged, my lord, my humble understanding, my lord, no effective order can be passed in favor of petitioner, my lord, in the such situation, my lord. In such,
We'll see. Person to during the course of deliberation, Mr. Parme was directed to obtain necessary instruction from the respondent authorities as to the number of vacancies lying vacant. The number of posts lying vacant since 3rd of February 2021. Mr. Parme, Parme has accordingly obtained instruction and apprised this court that only 4 posts are lying vacant. In the given facts and circumstances, this court is inclined to direct Mr. Parme, learned counsel for the respondent authorities, standing counsel for the respondent authorities, to file a detailed affidavit regarding the number of vacancies that have arisen since 3rd of February 2021 till 31st December.
Yes.
31st December, and raises at least the matter on 3rd of January 25.
That, my daughter. My brother wants to have celebration.
17. 17.
Yes.
Okay.
I don't want to spoil his new year. Oblige. Thank you.
List the matter, no, the matter stands released from further.
Oblige. Oblige.
Any other matter? No. Only Mr. Tapin matter. 11, 12. Yes, Mr. Tapin will. Yes, Mr. Tapin.
Lordship. Lordship, firstly, Lordship, so far, Lordship, this DGP, whether DGP can, Lordship, appoint the Lordship inquiry officer or not, Lordship. That part of the pleading is not there in the writ petition.
Acha.
Therefore, it has not been reverted by the department in the affidavit in opposition.
Acha.
That statement, as I said earlier also.
Ah,
So it is not there, Lordship.
acha.
Apart from that, Lordship, kindly come to the rule, Lordship. What the rule says, Lordship. 31, review power.
Page number
Page 24, Lordship.
24, yes.
This is the special power.
Hmm.
After Lordship appeal is rejected, review Lordship is an extraordinary power given to Lordship DGP.
This review, 31.
31 Lordship.
Yes, yes.
Otherwise, appellate power also is there, Lordship. Revision power also there, Lordship. Lordship, may I read Lordship? One. The DGP may at any time call for the records of the errors made by any of his subordinates, either on his own motion or otherwise, and confirm, enhance, modify, or annul the same, or make further inquiry or direct such inquiry to be made before passing orders. This is not the Lordship, the priest Lordship order. Power is before passing any order by the DGP. His order, this inquiry be conducted by this officer, and that inquiry report has to be submitted before him. Then only he will pass this order. This is not that inquiry will be passed, then the press proceeding will be drawn, Lordship. If Lordship.
No. The thing is that after they are exonerated in the departmental proceeding,
Lordship.
so the promotion of the petitioner was in Silgorwar.
Lordship.
That went to the DGP office
Lordship.
for opening.
Lordship.
Only then he passed the order.
Correct.
Yeah, that's all right. He has the power.
Yes.
But regarding appointment of disciplinary authority,
No. This is not the disciplinary.
No.
This is not the press disciplinary proceeding, Lordship. Lordship, kindly see the language again, Lordship. Here it says, Lordship, what power the DGP has been given. Kindly see. He can, Lordship, he can confirm, number one, enhance, modify, or annul the same, or make further inquiry. The second part, kindly see the second part, Lordship. Or make further inquiry or direct such inquiry to be made before passing orders. Before passing order, what orders, Lordship? This order is confirm, enhance, modify, or annul. Before these three orders is option is Lordship, chosen to satisfy himself, he can go direct for further inquiry, and that inquiry will be submitted before him. Then only he will exercise this.
No, but you see the wording here. Nowhere it is stated about de novo inquiry. But
Here-
in the impugn order, he has stated as a de novo inquiry.
Here, Lordship, it says, Lordship, to make further inquiry
Further inquiry and de
or
novo inquiry.
or direct such inquiry, Lordship. Such inquiry.
Such inquiry.
Such inquiry under
Such inquiry will cover de novo inquiry.
de novo, as I have stated, Lordship. De novo, the term is technically the term is there, Lordship. From evidence stage, Lordship. This is the Lordship. I should say is the Lordship, the language, which is the main Lordship.
But you see the latter part.
Direct such inquiry to be made before passing orders. What orders, Lordship?
but
Before,
he has already annulled the order.
no, this impugn order,
Hmm.
Lordship, here, can you see the impugn order, Lordship? The impugn order, Lordship,
Hmm.
to de novo inquiry, so and so by so and so,
Hmm.
from the evidence stage. And experience be sought from the inquiry who gonna define in the, so this is another aspect. Till finalizations of the promotion case of the Susan Services in Kif 7. Till finalizations of inquiry laws.
Hmm.
Because Lordship, by serial number 2,
Hmm.
the authority has order for inquiry to be conducted,
Hmm.
on which he is going to exercise his power under
Hmm.
Rule 31. Rule 31, part of the Rule 31 has been exercised.
Hmm.
The full order, final order is yet to be exercised, Lordship.
Hmm.
Because as Lordship has seen under Rule 31, Lordship,
Hmm.
before he can straightway annul or enhance or whatever he can confirm.
Hmm.
But he has an option before doing that, Lordship, he can go for further inquiry, and basing on that inquiry, Lordship, he will take decision.
No, here you see for serial number 1, he has already annulled the order, earlier order,
The earlier order
passed
has
by the SP Naharlagan.
the conclusion is here, Lordship,
Hmm.
because only the exonerated, Lordship. Until unless that is, Lordship, annulled, Lordship, then questions of further inquiry does not arise, Lordship.
Hmm.
Because Rule 31, Lordship, 2 parts, Lordship.
Hmm.
State where he can annul,
Hmm.
or to satisfy himself, Lordship, he can order for inquiry, and basing on that inquiry report, he will take decisions, confirmation, enhance, annulment. But the part of the review power has been exercised, and part is yet to be exercised.
Hmm.
So therefore, this is not, Lordship, someone has been appointed as to go for the novo, Lordship, departmental proceeding. This is only the inquiry under Rule 31 only, not the, Lordship, press inquiry. This inquiry is purely for the purpose of Rule 31.
Hmm.
Then so,
Any other point?
that's all.
Lordship may decide the matter. Lordship may decide the matter.
Pardon?
Lordship may decide the matter now.
How, Mr. K. Saxena, Learned Counsel for the Petitioner, and Mr. S. Topin, Learned Senior Government Advocate for the Stateless Woman. Argument concluded, judgment reserved.
And I'm sorry for
No, no, no,
sorry,
nothing.
inconvenience.
It's my duty.